So, welcome, and on behalf of the American Society of International Law, I'm delighted to welcome our panelists to our discussion on the Singapore Convention on Mediation and the future of appropriate dispute resolution. Our thanks to Curtis Millay for its sponsorship of this panel. A brief background on the Singapore Convention, as many of you know who are watching. It's been described as marking a significant turning point in international mediation, as it offers a new legal framework for the resolution of cross-border disputes. So today, our panel, we're very fortunate to have four experienced and thoughtful speakers who have been directly involved in the development of the Singapore Convention and have also followed its developments both in practice and also through academic research. Together, this panel will address the various aspects of the theme of this discussion. And so now it's my great pleasure to introduce our panel members. First, we have Edwin Tong SC, who is the Singaporean Senior Minister of State for Law and Health, and he is with the Singapore Ministry of Justice. He will offer perspectives from the Singaporean government on the convention and its development. We also have Itai Apter, who is the Director of International Civil Affairs at the Israel Ministry of Justice and was also actively involved in the process of creating the convention and has also spoken thoughtfully about the implications of this convention. Again, we have our third panelist, Mark Califano, who is the CLO of Nardello and Company, who is formerly with General Electric, and he will offer insights from a practical perspective on the needs and concerns of stakeholders and potential users of both the convention and also ADR more generally. And then finally, we're honored to have Andrea Schneider, who is professor at Marquette and one of the most important, thoughtful speakers and academics in the area of ADR in the United States. She's written extensively on concepts of ADR, particularly in a cross-border context, and she will be speaking on the implications of this convention on cross-border dispute resolution. So now with these introductions, we're ready to jump right into the panel. We have designed it as a discussion. So we have a few topics that we will be exploring in turn. I'll direct the question to one of the panelists who will address it, and then other members of the panel are most welcome to add their thoughts and additional insights as they wish. So our first question goes to Edwin Tong. Since this Singaporean convention is named after Singapore, it's had a very significant role in the development of this particular convention. The delegate was chair for many, for the majority of this development of this particular convention. So we would be grateful if, to start off this discussion, to hear Edwin's thoughts about the genesis of the Singapore Convention and how it came into being. So if we can turn it over to you first, Edwin.
Thank you very much, Shala. Thank you to all of you as well for having me here. I'm really in a very distinguished company. What I'm going to do is to give you a very quick outline of the genesis of the Mediation Convention, how we got here, and I think more importantly, how we see ourselves moving forward, because it's important for us that having achieved this, I think amongst the mediation community, what we regard as a significant milestone, that we don't rest on our laurels, that we decide how else we're going to step forward, how we're going to make sure that mediation is going to be adopted and become very mainstream in dispute resolution. I think we all agree that the Mediation Convention is really a game changer for all of us in the context of international commercial mediation, especially in the context of trying to promote, and I suppose saying this in these times now sound a little odd, but try to promote cross-border trade, travel between countries, and international commerce. It's really, at the end of the day, a powerful statement in support of multilateralism. And we in Singapore see this as the missing third piece in the international dispute resolution enforcement framework. Actually, even before the Mediation Convention itself, it's mediation has been on the rise for many years. I was in practice, in the legal practice, for about 25 years before I took up this present appointment. And I was a litigator. And oftentimes, when I stepped into court, even in the 1990s, the judges, whether formally or informally, would be asking counsel, have you considered negotiation? Have you talked about mediating the disagreement? And so, whether informally or otherwise, it's been present for a long time. But it certainly has been on the rise for the last 10, 15 years or so, mainly because parties see this as a very cost effective way of dealing with the dispute: flexible, efficient, confidential. And what I particularly like about it is that parties really have control over the outcome of the dispute. You're not constrained by what you might want to do because of the law, and you're not constrained by the shackles of legal paradigms or remedies. And you can be very inventive and forward looking in designing the solution. So it is very, very attractive for businesses who find themselves in a disagreement, perhaps with a long standing partner, and they want to preserve the goodwill and the long term relationship. And so this we see complementing other modes of dispute resolution like litigation and arbitration, gaining benefits around the world. Let me just cite the 2016 Global Pound Conference survey, where it was found that an average of 60% of delegates from various regions believed that they wanted to place more emphasis on collaboration rather than looking at how you do straightforward dispute resolution in the context of litigations or arbitrations. One key obstacle, I think we all know, has hitherto been the fact that we were unable to enforce internationally settled agreements. So, between two international parties from different jurisdictions, having different home rules and home laws on how you do enforcement, that has always been the problem. And looking at domestic regimes, some of which might well be at different levels of maturity compared to others. So, it is in this context that the Singapore Convention on Mediation has proven to be particularly useful because it's pushed through the boundary, pushed through the barrier of being allowing parties to have a more efficient, harmonized framework across different jurisdictions, across different laws, to ensure that parties enter into these mediations with the confidence that at the end of the day, the enforcement will not be riddled with procedural obstacles. So that's why we wanted to push so hard. And I think that really probably reflects the sentiment around the table today. We have the privilege of myself, not directly, but with my colleagues here in the Ministry of Law, having seen the workings of the various committees, the working groups. Itai, I think, can speak more to that later on. But how that had been done has had some history. And I thought, since my topic was the genesis of the Singapore Convention, I thought I'd spend a little bit of time going through that. You all know that it's not the first time this issue has been raised. Back in 2002, in the Ancestral Model Law on International Commercial Conciliation, it had been raised. Then it was prepared but did not succeed. New mandate was then given to the Commission. Why? Mainly because there was a recognition by member states that it's been increasingly used in cross-border disputes. There's been a growing universal acceptance of the acceptance of mediation, the legitimacy of mediation, and that has been so and growing despite differing national stages of maturity in terms of the adoption and what domestic laws might see. Partly because also there was also a growing acceptance of international mediation institutes, growing calls for neutral accreditation standards, fueled by a desire by the business community to want to find more cost effective, cheaper, and more innovative ways of resolving the disputes. I think all of that came together to give it another push and to propel Ancestral into looking into doing this again. And if you just jump forward to 2018, in the Queen Mary University of London survey, 49%, and this is before the SCM, 49% said that ADR was the preferred method of resolving cross-border disputes, and 60% of them found or said that they preferred to have international arbitration together with ADR, compared to just 32% who said they would resolve these disputes through a standalone arbitration. So this, I believe, gives you the history and the background as to why there has been a push, not just because of the laws, not just because what council says, but ultimately because of the business community. And I think that's the real driver in the success of mediation today. I would add, and I think Itai can speak to that as well, there's also, I think, a good synergy in the working group between parties who came to the table with an open mind, despite coming from different backgrounds, despite having their own limitations domestically, but with the central objective of trying to find consensus. And I think within the working group itself, you can see the seeds of mediation originate, how parties came together, how there were sticking points, how there were disagreements, but coming together nicely. And there was one famous story, of course, and I think, again, Itai might have been there, I'm not sure, where the delegates were locked out of the UN because of a massive snowstorm in New York. But they were able to find a bar close by. They all huddled in the bar, I'm told, and after a couple of drinks, decided that they would not leave the bar until they found resolution on areas of disagreement. And I think that gave the convention a big push and ultimately resulted in that. I think Itai wants to speak to that as well. I'm not sure if you were there, Itai, but you can share your experiences and you can verify the veracity of my story later on. But as I mentioned earlier, and I'll just tail off with a couple of minutes on how we see ourselves moving forward, because it's important to have done this. It's important to have listened to what the business community wanted, but ultimately, I think it's what we make of it, how we strengthen it, how we enhance it, how we add to the thought leadership behind it, that really would define how we we see and use the convention. So, what are the couple of things that we have done in Singapore? Let me just quickly outline them for you and just share our experiences. First, we've been very active in making sure that we promote mediation as a tool. That sometimes sounds like it's so simple, but actually it's sometimes counterintuitive for parties to be embraced or engaged in disputes to think first of trying to resolve the disagreement. And we've done that through a series of our mediation institutions. We have the SIMC, Singapore International Mediation Center, the SIMI, the Mediation Institute. We set up SIDRA, which is the Singapore International Dispute Resolution Academy, making sure that we harness thinking, worldwide thinking behind mediation, how we push the envelope on thought leadership. And of course, the SMC, the Mediation Center, which looks after domestic mediation cases. SIMC has worked very closely with various touchpoints, lawyers with the Law Society, the Singapore Corporate Council. SIMI has been instrumental in making sure that professionals in the healthcare and built environment sectors, they are people we believe would benefit from the use of mediation. And they've been very proactive in stepping up engagement sessions, seminars, conferences, and so on. Ourselves at the ministry, together with universities, have been doing so. All three law schools in Singapore provide students with electives and modules on mediation, specifically to develop students' interest in mediation from the start. And in fact, many of these students volunteer at mediation sessions even before they qualify into practice. So we believe that starting them young and obviously putting them into the thick of what it means to do mediation would have a longer lasting effect. Providing internships for students as well to deepen their own understanding of mediation would we find be useful. Ultimately, what else do we do? I think we have to start and end with the courts. And I'll leave you all with one last point as to what we're doing in the court. We have in the state courts a presumption of alternative dispute resolution for all disputes. So what it means is that every case that travels through the courts will encourage and in some cases mandate the parties to consider ADR as the first stop for resolving the disputes. And as with most things with lawyers and counsel, we incentivize them by telling them that if a case could be reasonably resolved through mediation, and it's not, then there could be cost consequences. And I think that really puts the picture into perspective. So judges are very proactive in trying to conduct judge-led conciliation. Um, as an example, presiding judges sometimes conduct case management conferences during which they suss out the parties, where the real lines of disagreement might be, and encourage the parties to participate in ADR. In other cases, we have collaborations with the Supreme Court to refer these suitable cases to the SMC, and we do that at no charge for a period of time so that we can acclimatize parties to help litigants think about mediation as an option even before considering others. Um, Last point, with this framework, we believe that it really takes the whole community, whether it's the government, the judiciary, legal professions, students, academia, mediation institutions, and so on. It really takes the whole of the society, whole of the environment ecosystem to make this work. And we in Singapore are very committed to doing so. And we are very glad that we were the first country, together with Fiji, to ratify the convention. Since then, Qatar and Saudi Arabia have also ratified, and which means that it will come into force on the 12th of September later this year, in a few months' time. And we hope that despite these COVID-19 times, that parties will find countries will find ways to adopt the convention and allow for the business community to use the convention on a more regular basis. I'll stop here now. Shala, thank you very much.
Thank you so much, Edwin. That was a wonderful background and very helpful sort of lead into our discussion and our next topic, which is going to Itai. And yes, please feel free by all means to share more about this sort of snowstorm incident. I've heard bits of this, and it would be wonderful to hear a bit more about that. And also any of your additional thoughts about the current status, the current sort of development of the convention and its global uptake, what you see as its utility in the global context at this stage. You were, of course, present in the development of this convention, so any insights also on the process would be most welcome. So I will turn it over to you, Itai. Thank you.
Thank you, Shala, and thank you, everyone. I really wish, I think all of us wish that we could be in Washington, D.C. with everyone. Basically, personally, I wish I could be anywhere abroad, since our airports have been virtually closed for the past 3 months, but this is as close as it gets to being abroad, so that's good. I'd just like to add maybe a couple of things to Edwin's very insightful presentation. Of course, the snowstorm is a famous story, and I'll correct Edward. It's not that we didn't spend a lot of time talking about the convention in various bars in New York and in Vienna, but this time it was a law firm where the Canadian delegate found a law firm that was willing to host us during the snowstorm, and we all tried to find our way in the snow, find taxis. It was very difficult to get there to that law firm, but we did find a place. It was empty. No one was there except us. And it is right that we didn't leave until very late at night when we decided that we can work on a compromise. And I think just to mention, Edwin's colleague, Natalie Moise Sharma, was the chair. She was not only a very eloquent chair and a very good one for the rest of the session, for all the session, all 3 years, but also during that snowstorm, she took care of drinks and food for everyone. We're not sure whether she paid it out of her own pocket, but that was a very good effort on her part, and it really contributed to the success of that part. Another thing I like to add, and before I discuss the current status, is another side story about how the Singapore Convention got its name. Of course, the substantive reason, it was mentioned by Edwin and by yourself, that Singapore had a lot to do with starting with the discussions about the convention and the negotiations, but Israel was very proud to be the delegation that suggested that the convention be named after Singapore. And we're very happy to be able to do it on the floor, and we are even more happy to see that Singapore agreed after we suggested it. So that's another nice story. And I think it really signifies the contribution of Singapore. So as to the status of the convention, well, today we have 52 states which have signed the convention, at least according to a last count, and 4 states which have ratified. So it will indeed enter into force in September. We know of another country who is supposed to ratify, and Israel itself is. We are very diligently working on ratifying the convention. We have finally an elected government, which we didn't have for the past year and a half. Now they're mostly busy with Corona stuff, but we are also encouraging. We think that Singapore Convention is very much related to the COVID-19 crisis, so we are trying to do our best to ratify the convention as soon as possible. On that note, I just want to highlight that 52 states in a year is really a remarkable achievement. We looked at what happened with the New York Convention, even on enforcement of foreign arbitral awards, and on other UNCITRAL conventions like the Transparency Rules Convention, and we think it's some sort of a world record. 52 states signing or ratifying in a year. Maybe seems a little bit slow for people who aren't familiar with conventions, but it's definitely an achievement. And I think it's a hallmark of the way that the convention was drafted. It was drafted in a very, very balanced way. I think each and every delegate who participated got out happy out of this because we really reached a very balanced product. We know, and I know personally, and a lot of people came up to me and told me that it's not a perfect convention, that they see a lot of limitations in it. Maybe Mark will discuss it forward later. But our approach was, and we're happy that also Singapore had the similar approach, that we're not aiming for perfect, we're aiming for something that will work. And we see that states have really endorsed it. So the main thing about the convention, the main utility of the convention is that if until up till now, if you wanted to enforce a settlement agreement, international settlement agreement, it would be in another country, it would be the same way as you enforce a contract. And that with no obligation, no commitment, and Edwin was right in saying that this was a deterrent for businesses, especially the big ones, to really go and use mediation because the contract is not, it's very hard to see how it will be enforced or not. And the convention really creates a mechanism where a country really takes it upon itself to obligate itself to enforce any international mediated settlement which comes its way. And it's also interesting that we purposefully, aimed at not having a reciprocal mechanism. It means that it doesn't really matter where the settlement came from. So it could be a settlement that was reached in a country which is not a member state. It could be a settlement which was reached online. Wherever it was reached, if it answers the conditions of the convention, then the member state has the obligation to enforce it according to the terms of the convention. So this is a very big step forward. And I think that for a country like Israel, and we saw that a lot in consultation internally, for us and for our actors, especially now due to the COVID-19 crisis and not being able to travel, it's very difficult to conduct, for our business people to conduct very complicated arbitrations, very long ones, very pricey ones. So if they will have the possibility of mediation, and more so if companies from much more economically strong states will agree to mediate with them, then they can do it much more simply online, or it would only require to travel once. So again, on the travel, the personal thing for me now, if we want to travel, when we come back, we have to spend 14 days in isolation. So if someone needs to do an international arbitration and travel a lot, then you should put it to a minimum. So I think that's a very big plus for the convention. And I agree with Edwin that there could be problems now with countries really focusing on the crisis. But on the other hand, if we see the convention as something that can really address the current economic crisis, current travel crisis, then definitely states will be much more willing to push it forward. And our hope is that by the time that maybe in 10 years' time we'll reach the number that is now the New York Convention on Arbitration, which is I think around 160 states members ratified notification. So if in 10 years, I said it also before in other panels, if in 10 years we'll have even half, then we'll really make a very, very substantial contribution to dispute resolution and to cross-border trade. And finally, I also want to note the great compromises and mediation really that was in the convention. We had a very difficult time. We had a lot of opposing views, but we had also mediators in the room, and some of them also helped us reach conclusions and compromises. So one of the hallmarks of the convention is that it was really always a mediated settlement. And every day we mediated, every day we settled. And to do a convention like this in 3 years' time is definitely a record for international law. And hopefully this will also serve as a role model for other treaties and other conventions. Thank you.
Thank you so much, Itai. I think that's a really wonderful example, as you were describing, of how the means match the ends, and the means that were used in the process of the drafting really reflect the aims and goals of this convention. So it's very inspiring, and it's also a great, as you mentioned, a great model of global dialogue. So that's a really wonderful segue then to Mark, who is going to be sharing a bit, and we'd love to invite you to share more about the practical sort of implications as corporations and other entities are looking to use this convention or think about how they might engage with mediation in the resolution of commercial disputes. What you see as some of the opportunities that this convention offers, as well as some of the limitations, how it might interact with domestic mediation practice, and any thoughts too about sort of the role of the EU in this future development of the convention or its participation. So we're handing over to you to share your thoughts from your experience in terms of the use from a commercial perspective. Thank you so much, Mark.
Thank you, Shella. I think first of all, it's important to remember that what most corporations do, especially multinational corporations, when they're trying to protect and secure the investments they make in their complex commercial cross-border arrangements and agreements, really do require, to be very effective, a couple of different types of dispute resolution processes. And often when you are looking at significant joint ventures, significant commercial agreements, you will see combinations. And some of the most effective, when we talk and advise our clients, when I was at both GE Capital and later at American Express, we remind them that having escalation, having mediation, which is required by the parties before we even get to an arbitration or any other kind of litigation, is really important, because that often gives the commercial client, your business client, some of the best opportunities for influence in trying to resolve an arrangement. Mediations allow for much more of that type of client input. They also, I think, allow for much more fluid solutions to problems that once they get to an arbitration and what I would call something that is a little more procedurally bound, can sort of limit the ability of a company to find a solution that allows it to, one, continue to make profit off whatever agreements and efforts they're trying to do, and two, to avoid wasting what can be a considerable amount of cost. So the fact that we now have a convention that allows for the enforcement of settlement agreements is a really important thing. I think that people who are not only negotiating these agreements in companies that work overseas and across borders ought to look at this as a really great opportunity to encourage early settlements of those kinds of issues. And frankly, early settlements and, where necessary, quick enforcement, right? This should be something that's not only encouraged in the use of mediation, but it's something that I think companies can often encourage through international chambers of commerce to urge their partners to ratify and to sign and to join on to this. I think that one of the things that, and having had this experience in many situations, trying to come after a contract has started to be performed and we have issues with the contract, trying to mediate and then get a settlement and then literally have to litigate that contract again is exhausting for a company. And in many cases, companies, after a number of years of having to do this, especially in particular jurisdictions, can get frustrated. It becomes a major factor in whether or not they want to continue investments and to really put a lot of effort into the kind of development and the growth of trade that we all need. Having something like this, even if it's not perfect, and frankly, even enforcement of arbitration awards is never entirely perfect, um, still encourages people to abide by their agreements, to take mediation seriously, to not use it as what I would call a bypass or a prelude or pre-discovery to arbitration. And the more I think that lawyers and companies and the outside counsel of these companies educate, especially not just litigators, but transactional attorneys on the value of this, the more you're going to see people start to think it through, start to incorporate it in their agreements, start to think about how to operate businesses with the understanding that this is an option. If we want to talk about the practical implications, look, especially in the era of COVID-19, it is a significant effort and it's a complicated effort to put on arbitrations and to conduct litigation. If I've been talking to my colleagues, especially over the last 3 months, trials are an incredible effort. Arbitrations are a really significant effort. Even mediations can be a little bit of work. I've heard stories about how sometimes breakout groups to have their parties go to their separate rooms can get complicated when people don't manage those carefully and people pop in and out inappropriately. But the one thing that is really clear to me and to a lot of my colleagues and the kind of companies that sell and market around the world, that gather resources and have supply chains that cross multiple borders, is that the ability to have an effective mediation is much easier than almost any other type of dispute resolution process online. And it allows them, by the way, to bring in their clients in the appropriate way. It allows them to manage progress in the appropriate way. It, frankly, is one of the less cumbersome efforts that you can do. And so right now, it's probably a lot more valuable, or at least a little more valuable than it had been before. And I think that's something that, people will, again, turn to, take a little more seriously, put a little more time and effort into. All of that is going to only make mediation more valuable. I think, in the course of reviewing a convention that hasn't necessarily been used yet, the one couple of things I can see that I know colleagues will be sensitive to is, first of all, even with this expedited process that member states are going to commit to, there are opportunities here for additional litigation that may delay things and that may delay enforcement, right? There are arguments about enforcement being contrary to the jurisdiction's public policy. I can see some mischief being made of that by people who don't want to comply with an agreement. I think sometimes there will be interpretations of agreements that will come remarkably similar to dealing with a contract dispute, but I don't necessarily think it will involve the extensive litigation and process that's often involved in a contract dispute. I think that having to require, which I think is necessary, that mediators somehow sign off on or indicate their involvement in this, and then again, having an opportunity for somebody to object to enforcement on the basis of misbehavior of a mediator can get complicated. That is a process, especially in the US, which is quite a bit more confidential, where mediators' involvement in going back and forth is not something that really is open to discovery litigation, very rarely, if ever. And I think it's going to require some adjustment in contracts and arrangements to do mediation that may have to, in some parts, appear in a contract. There are going to have to be certain clauses that make sure that whatever agreement that comes out of mediation can accord with the requirements of the convention, for example. And that, again, was something that, just as we had to do with the enforcement of arbitration awards, it's going to require experience. It's going to require a number of cases to go through the system. It's going to require a little bit of precedent to develop in each of those countries. Those are some of the basics. And Shala, the reason I'm going to ask some of my colleagues on the panel to sort of say what they see is because I think having Itai and Edwin and Andrea here, they've also been very sensitive to the development of the convention and some of the issues that they were present for negotiating, which probably could presage some other issues they see coming up in this. So I want to invite them to see if they see issues and areas that people might want to be sensitive to and aware of as we start using the convention.
Thanks so much, Mark. Yes, please. Anyone feel free to jump in if there are issues, practical sort of application points that you think would be important to note at this stage in terms of contract drafting, enforcement. Feel free to supplement as you wish.
I think one of the points that will come up as we slowly begin to introduce, or rather reintroduce mediation into the contract world, into the drafting world. I mean, first you'll have parties from different home countries having different systems. And I think the level of assuredness that they have with the concept of mediation and how they see enforceability of awards and agreements. Awards people know of. I take Mark's point. I mean, there are also imperfections in enforcement of arbitral awards. So I think one should not be too harsh on enforcement of mediations. And it's still also in its nascent stages. But also, I think in terms of socializing it with the business community, I think people, when we go around and people ask us, what's all this about trying to get into a room? I mean, where are my legal rights? How are they going to be enforced? I mean, we've drafted agreements which make it clear, if that's not delivered, some remedies would follow. So why do we have to get involved with the mediation when we want just our pound of flesh? I think sometimes the psychology and the psyche of the business community needs to be managed as well. And I would say we should not underestimate that, because especially when we talk about cross-border mediation, the home cultures, what you're used to, the practices that you've been used to, sometimes is not as portable as one might expect it to be. So we just have to bear that in mind as we push out and roll out I mean, it's easy to put out the agreements. The clauses are fairly standard. But what people think mediation means might differ from jurisdiction to jurisdiction, country to country, and culture to culture. And I just hope that we can bear that in mind as we push out, that the softer side of mediation, softer side of the acceptance of mediation should also be emphasized.
I think maybe just one minute. Don't want to keep Andrea waiting. 2 points. The first point is that people have to be aware of the reservations that countries enter, because the possibility to enter a couple of reservations, and I can expand on that later to see if a country did or not. And referring to what Mark said, mostly the defenses really reflect the balance between a very strong common law approach and a very strong continental law approach. And I think that after a lot of work, we arrived at something that's very balanced, but obviously not perfect. But it reflects a very hard-fought compromise in the work.
The one thing I will add about the common law, continental law compromise is I think that issue is pressed across every one of the commercial agreements I've ever seen that has gone into and out of common law and continental law countries. And even with that challenge, I think it's really very important that we have this type of agreement. It's never going to make anybody completely comfortable, but to force people to understand that we all have to go through a relatively similar process. Frankly, they're going to be introduced to this one way or the other. The one thing this does do is it allows some input into a process that everybody is familiar with into another legal system. And that to me should make a lot of clients a little more comfortable about the fact that this is mediation by structure is a lot more efficient. Enforcement, anytime you can make it more efficient, is always going to be more helpful, especially if you think you've got an agreement. And frankly, to get over that hurdle, which is sometimes a hurdle with certain clients, and unusually in multinationals, you actually can have countercurrents of comfort with common law and civil law, depending on where your executives sit. I think it's going to be positive.
Well, that's a great segue into our questions for Andrea, which really do touch on sort of selections of forms of appropriate dispute resolution and how this convention may impact the development of both non-adjudicative forms of international dispute resolution, but also its impact on more traditional forms of litigation, arbitration. So yes, we would love to hear your thoughts just in terms of the development of the field of dispute resolution in general, and particularly in the cross-border context.
Great. Well, thank you all for having me today. This is, as we've noted, not the same thing as being in Washington, D.C., but lovely to see everybody and get together. And as we've duly noted, from time zones all the way from one end of the world to the other, we've already demonstrated that even in this time of crisis, it's actually pretty easy to get everybody together in the same room in ways to have a conversation that demonstrates some of the ease of mediation that we hope companies will take advantage of. So I want us to think about the impact of the convention and how that might affect both state and companies' behaviors as they move forward. We've had for a long time the phrase bargaining in the shadow of the law. And then more recently, and particularly when we look at international investment, it's bargaining in the shadow of international arbitration. We know that it could end up in arbitration, and therefore, how does that impact behaviors before that? And I want us to think about what might bargaining look like in the shadow of mediation. Not that mediation is necessarily going to set the law in the same way that arbitration and litigation have precedential value, or at least informative value in the arbitration scenario. But when we know that mediation is the next process that we might take advantage of, what is the trickle-down effect really in terms of those conversations that are had between governments and investors as disputes arise, and to think about what that process impact might be as companies are now dealing with various and sundry concerns that they have when they're investing. I'll start at the outset with some of the bad news. The convention's obviously not going to alleviate the problems that have been tracked by the World Bank and others in terms of securing foreign direct investment. There still will be a political cost to settling voluntarily, whether it is for an agency or for a government. The political cover that countries are able to use when they say they've been forced to pay out to an investor, perhaps against their will, is still not going to be provided in mediation. And so that's still something for us to be thinking about. Coordinating between different agencies in the government. In some ways, once arbitration has been filed, it goes off to a particular place. Most countries now have figured out how that process works. Mediation is going to require coordination between those agencies promoting investment, those agencies that are regulating, and now the agencies that may in fact be responsible for the mediation. And that coordination in some ways will be even more heightened in a mediation process where the real goal is to get everybody in the room to talk about what's happening on the regulatory side or on the finance side versus who might in fact in the legal department be pursuing the mediation before it hits arbitration. And the incentives for agencies in government could well be different as well. And so to the extent that there are certain agencies, and again, this gets even more heightened when we're looking at federal, state, or local and national differences, there are going to be different incentives for those agencies. And so oftentimes you're going to have state or local regulatory agencies that are the ones that are actually driving the dispute, in particular by a regulation that they've imposed. That's going to have a different incentive structure in terms of staying in power or demonstrating that you're taking care of your citizens to the federal or national government that has in fact encouraged the investment in the first place. And mediation by itself is not going to solve those problems. It may provide a better process for harnessing that. And that obviously is the hope, I think, behind the push to really think about various processes in order to try to manage those differing incentives and different audiences, as it were, in terms of how different agencies, government officials, local and national, get rewarded for effectiveness in their behavior in monitoring foreign direct investment. So let's look at the good news, as it is. And I like, and I think Mark used this phrase, socializing companies to use mediation. Is there something about this convention and now everyone really utilizing this that normalizes mediation, that socializes both companies and governments to use mediation? And in terms of socializing that and normalizing it, that then gives us far more ability to be creative as we're thinking about those non-consensual dispute resolution mechanisms, even before we get to mediation. And as others have noted on the panel already, it's not just the lawyers that we're talking about who may have gone to law school, as Edwin noted, whether it's Singapore or any other country. We are all rife with ADR classes and mediation clinics, and it's not this generation of lawyers who are graduating that are unfamiliar with ADR. It's really a question of how are we socializing our clients, our government officials, and everyone into this new understanding of processes. So really thinking about first, how do we coordinate and get those conversations among agencies at the federal and state level, at the national and local level, and to have those conversations about how we are protecting and promoting investment. How do we both promote and regulate? Because what we've seen is whoever's responsible for promoting is not necessarily the one following up after there's been some problematic regulation that is making the investor unhappy. And so again, if mediation is able to build that, socialize that, really, those conversations, that is a huge advantage. How do we, second, think about investment and between the investor and the applicable agency? When we think about mediation, we have to think strategically about who is at the table. In some ways, this may well be that how everybody negotiated the Singapore Convention, right? Getting everybody at the table and thinking about the important people who need to be there, role modeled really well the importance of having a lot of different players at the table. To the extent that mediation really starts to role model for us the importance of getting everybody at the table, investors at different levels, the government agencies at different levels, this may well help us identify who we talk to, not only at the mediation, but the next time around even sooner, right? If I now know, oh, there were these 5 people who all had to be in the room when I mediated this particular problem, let me pick up the phone the moment there's a dispute, because now I know them, I've seen them on Zoom, I've seen them in the room, whatever it is. That identification of all of those multiple interests could well move dispute resolution earlier in the process. And in all of the studies, World Bank and otherwise, that have looked at how we effectively keep investment and minimize disputes, it's all about that early intervention. And whether it is really, I think for the third point I want to make, thinking about how we promote those, whether they're the strategic investment response mechanisms, as the World Bank calls them, other people have called them consensual dispute resolution mechanisms, whatever they are earlier in the process, that really enables the investors and all of the government players to get together sooner, long before this is something that is filed in arbitration. Because what we know is that once it's filed, the investor often has decided to withdraw. And getting that investment back is far harder than keeping it in the first place. So that early intervention, those early dispute resolution mechanisms, serve everybody's interest in terms of flagging that dispute, flagging the appropriate people to have that conversation with, and keeping that investment in the country. The last thing I'll think about is we've talked over the years in terms of access to justice and differing countries' abilities to have skilled lawyers involved in the arbitration, in the international arbitration community, how much it costs, obviously, to go through arbitration. Mediation can be a huge cost savings. And again, by getting more people involved early on, I think that access to justice can really continue to be trumpeted for countries across the globe in terms of how do we keep investment, the lessons that we're learning from that earlier intervention. Roberto has referred to this as divorce therapy for between companies and countries. And again, much easier to get that therapy early in the marriage than it is once you've filed for divorce papers. And so really thinking about if that mediation normalcy can help us think about moving those dispute interventions earlier by virtue of identifying who needs to be there and really normalizing this kind of process altogether. And I'll end where I started, which is, if you can get all of us together in a room, it's going to be, even in these times of crisis, hopefully manageable to get others in the room as well.
Thank you so much, Andrea. That was really a wonderful sort of tying together of sort of the theoretical and also practical impacts of this and where we might look going forward. Speaking of getting us together in this room, I wanted to acknowledge and thank also Susan Frank, Jared Wong, and Megan O'Neill, who were the ones who really were behind this panel and who really helped to find and bring together these wonderful speakers. A question that sort of came up that was brought forward by Susan and based on some of the discussion we were thinking, in terms of what is the impact now. Many of you have mentioned COVID and the sort of current pandemic. This is the reality now that we are all in, and we share that. We, as was mentioned, we're here together, but we're also in multiple jurisdictions. So looking at the impact of this on mediation itself, Susan mentioned there was the Columbia Center on Sustainable Development paper, which was suggesting a moratorium on all investment arbitration in light of the current situation. I also have read of the British Institute of International and Comparative Law. Just in April of this year, they brought together a group of individuals within the UK, and they were looking also at this impact, and they were saying that in the current situation, the impacts of COVID is going to have, it's already had devastating impact on commercial activity, and this could give rise to a deluge of litigation and arbitration that would place a strain on systems of international dispute resolution. And so what they also suggest is this concept or this idea of breathing space or giving a pause, where offering some sort of temporary relief to businesses and individuals who are unable to fulfill their contractual obligations because of COVID-19. And with this breathing space to sort of facilitate forms of conciliation so that parties could continue a viable contract rather than bring it to an immediate end. And to seek out some equitable readjustment of relations so that no one will be unintentionally enriched at the expense of the other. So that's the idea behind this. So there have been calls from various sectors, both academic and professional, legal, for very much what we're seeing in this convention, which is a pause, a way to really rethink and think holistically, globally about how all parties can get the benefit of their relationship and their contract, but also take into account current strains on the system. If anyone would like to make any final concepts or insights on our current situation, you're most welcome. We have a couple minutes left to do so. So please feel free to share your final thoughts.
Maybe briefly to respond to that, I think all of us at the table, when we negotiated the convention, many of us said that it's really not, the convention would be a success if it's not used at all. So if we have the convention, and the thing that it would bring is that people would agree to mediate, and then they would not have to enforce the mediation agreement because parties would be deterred from non-compliance because of the convention, then this would be a worthwhile goal. And I think that now, if companies turn to mediation, then they can do so, at least with the ease of mind that at the end of the day, they'll probably not have to use the convention because there would be this deterrence. So I think this very much buys into Susan's point. And I think it should be a very good incentive for more and more states to sign and to eventually also
I'd just like to also add to this by saying that in Singapore, like many other jurisdictions, we've had an occasion to pass new legislation to mandate standstills, to mandate moratorium, essentially, like Shala says, to preserve the relationship between parties and to ensure that no one steals a march on the other because of non-performance during this period where performance of contracts and obligations really become that much harder, if not impossible. And in the context of these new legislation, our SIMC has also worked out a COVID protocol, which would be embedded and grafted into these new measures, because we see a lot of opportunity for mediation, similar to what Susan has put out. I think in this climate, you'll find that parties, even if they had legal rights to pursue, might have to think twice, if not three times, before thinking about embarking on a lengthy arbitration. So we see lots of opportunities for mediation now to fill that space, beginning with this kind of protocol where parties who find their relationships and contract disrupted because of COVID, finding space in mediation to try and resolve it and find a way to continue with their relationship. In other cases, I think parties could be less inclined when they will otherwise jump into court in litigation or before an arbitral tribunal, might pause for mediation a lot more than what they might have done before. So we have ramped up our resources. We have made sure SIMC is able to provide the platform for such cases. And we are really going out there offering services for mediation. And I think likewise in many other jurisdictions, that's likely to be the sentiment as well.
That's a wonderful note to end on. I know that we are now at our time, and I'd like to just finally thank each of our panelists deeply for all your insights and your work and your efforts in making this a reality. Edwin, Itai, Mark, Andrea, thank you so much for your participation and coming here together in the morning, the afternoon, and the evening. And thank you to ASIL for organizing and hosting this panel.
Thank you.
Thanks for having us.
Thank you very much for having us.
Thank you.